Good afternoon. I received this notice from my landlord and it was taped to my door yesterday. It doesn't really look official and I just wanted to talk with an attorney to find out what it means and what my rights are.
Okay, before I take a look at the document you received from your landlord, let me briefly go over the three main types of notices that a tenant can receive from a landlord that can lead to an eviction. Notice of non-payment of rent, notice of non-compliance, or a notice of termination of your rental agreement. Each of these notices are different. They each require a tenant to take action or face eviction. Let's take a look at the notice you received. The notice you received is a notice of non-payment of rent. This is by far the most common type of notice that leads to an eviction. It is commonly referred to as a 3-day notice. The 3-day notice must be delivered to you in writing and include the following information: a statement that you have not paid rent when it was due, the exact amount of rent due, the address of the leased premises where you live, the landlord's name, address, and phone number, the date the payment is due. Your landlord doesn't need to have the sheriff or process server deliver the notice to you. Your landlord can hand deliver the notice to you, tape it to your front door, called posting, or even mail it to you. The 3-day notice can only demand payment of rent, unless your written lease agreement says otherwise. Rent does not include late fees, security deposits, or costs for repairs. The 3-day notice must give you 3 days to either pay the rent or move out. The 3 days does not include weekends, holidays, or when the court clerk's office is closed, or the day the notice was delivered to you. Note that if you live in a mobile home park with more than 10 lots and you own your mobile home and owe the lot rent, the notice must give you 5 days instead of 3. Service is effected on the date of service, posting, or the date it was mailed. It is important to remember that in the case of mailing, the deadline may have started before you even received the notice in the mail. If the notice tells you to pay the rent to a post office box or an out-of-town address, you actually get a few additional days. But it is very important to work with an attorney to understand the deadlines. If your 3-day notice contains additional charges like late fees, or if you don't think you actually owe that amount contained in the notice, it is always best to reach out to an attorney for guidance. But you should do this as soon as possible once you receive the notice.
Can I pay less than the full amount? Does the landlord have to accept the payment?
Yes and no. Your landlord must accept your payment if you offer to pay the full amount of rent demanded in the 3-day notice by the deadline in the notice. However, your landlord may refuse your payment if it is less than the full amount demanded or offered after the 3-day deadline has passed. You should always keep proof of any payments that you make to your landlord. The proof should state the date and the exact amount paid. If possible, you should take a friend with you when you're trying to pay the rent demanded by the 3-day notice. This person can be a witness to what happened, even if your landlord refuses to accept your payment. If your landlord accepts your partial payment, you should always get a written receipt from your landlord with the date and the remainder of the rent that is due and when, and that an eviction will not be filed. If you do not get this written assurance, your landlord may issue another 3-day notice or deposit your partial payment into the court registry when the landlord files the eviction action against you.
What if I can't pay the rent owed within the time frame allowed by the notice?
If you cannot pay the amount owed, you have 3 choices. You can move out to avoid eviction, or if you want to try and continue living in the residence, you can try contacting your landlord to see if he or she is willing to give you some additional time to come up with the money. Or wait for the eviction lawsuit and defend against it. If you move out of the property, it is important to inform your landlord and surrender your keys to your landlord. You should also reach out to your local 211 agency, which can give you referrals to local social service agencies that might be able to help you pay your next rent. Please note, however, that your landlord is under no obligation to give you additional time, and that once the deadline to pay rent in the notice passes, and if you are still living in the residence, your landlord can then file an action in court to evict you. Once an action for eviction is filed in court, the fact that an eviction action was filed against you will remain as a permanent public record. That has the potential to make it really hard for you to find additional rental housing in the future. If your landlord tries to retaliate by changing the locks or even turning off the electricity or air conditioning, you should contact the police and attorney immediately. This is a form of eviction that is not legal, but it still happens to some tenants.
How do I know if and when an eviction has been filed by my landlord?
An eviction action starts when the landlord files papers called the complaint with the court. In an eviction lawsuit, the landlord's complaint can ask for possession of the rental unit as well as damages. They pay a filing fee to the court, and they have you served with the complaint and notice of the lawsuit, called a summons. As the tenant, that means you will be given a copy of the lawsuit, including the landlord's complaint and the court's notice of the lawsuit, which is called the summons. The papers are usually hand-delivered by the sheriff's office or by a private process server. If you cannot be found, your landlord can serve you by having a copy of the papers taped to your front door, called posting, and another copy mailed to you by the court clerk's office. After you are served with the summons, things move pretty quickly. You must respond with your answer and deposit all monies owed into the court registry before the 5th day. Or if you disagree with the amount of rent owed, you must file a motion to determine rent, to determine how much money must be paid into the court registry. If you don't respond properly, an eviction judgment can be entered against you 6 business days after you are served with the lawsuit.
Thank you for all your helpful information. I just have one more follow-up question. What if I didn't pay my rent because my landlord won't fix stuff in my apartment?
That's a good question. There's a process a tenant must follow to withhold their rent and raise it as a defense in eviction. Depending on what isn't fixed and a few other factors, there are things you can do. Please watch our next video to find out more on this particular topic.